The views and opinions expressed on this program are those of the participants and do not reflect the views of BronxNet or the program underwriters.
BronxNet. Your voice, your views, your vision.
Good evening and welcome to BronxTalk, the Bronx's flagship television talk show. Please weigh in with your ideas, questions, and comments by calling in at 718-960-7241. You can also email comments to us at bronxtalk@hotmail.com, and we'll read those on the air during a future edition of our program. Well, in a recent 5-4 decision that slid under the radar for many, the United States Supreme Court revised the nation's rules on so-called Miranda rights, deciding that they're not automatically applied when a suspect is being interrogated. While it might appear to be somewhat of a subtle distinction, this new ruling has implications into legal proceedings from the most fundamental cases here in the Bronx, all the way up to international terrorist investigations. To help us not only understand the court's ruling, as well as provide commentary on what it means for Americans and, of course, us here in the Bronx, we have the supervising attorney at the Legal Aid Society, Mr. Timothy Roundtree. Good evening. Thank you for joining us.
Thank you.
And also an attorney in private practice, Gulan Harrison. Good evening.
Good evening.
Ms. Harrison,
Thanks
thank
for
you for
having
joining us. We should mention both of our guests tonight are professors in the Monroe College School of Criminal Justice. So thank you for joining us. Let's start with you, Mr. Roundtree. I'm going to read it.
Sure.
You have the right to remain silent. Anything you say, and we're not directing this at you, but I'm establishing what we're talking about here.
I'm a lawyer, please.
Anything you want a lawyer, right? Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you cannot afford an attorney, one will be appointed to you. Do you understand these rights as they have been read to you? And in some states, including New York, they add, do you understand each of these rights that I have explained? Having these rights in mind, do you wish to talk to us now? Those are the Miranda rights and the Miranda statement that is read. It's reasonably familiar to most of us. What's the change by the Supreme Court and why did they do it?
Well, the change is that a suspect has the right to invoke his right to remain silent and the right to an attorney under the Fifth Amendment rights, under the Constitution, the Sixth Amendment right to a lawyer. The change in this particular case is that the individual was arrested, his name is Thompson, is in Michigan, at the Sixth Circuit in Michigan. Mm-hmm. When he was brought into custody, he remained largely silent for almost 2.5 hours. Mm-hmm. And the police officers continued to question him. And despite having him remain silent, they finally asked him a question, and the question was, do you believe in God? And he says, yes. And he said, did you pray forgiveness that you shot this individual who was shot? He said, yes. And that yes, the answer to yes was used in court. He was convicted of murder in the first degree and sentenced to life in prison. So he actually, the position from the lawyer was that he in fact invoked his right to remain silent by in fact remaining silent. And that the rules say that the only way when you invoke your right, you can waive those rights if you then later decide to make a statement. The court interpreted the fact that he answered the question that he waived those rights after invoking the right to remain silent. And actually,
now, let me just interject. Had they read him those rights
they certainly did.
So they did, and then he didn't say that I'm going to remain silent. He simply sat there, which according to what they told him, he was allowed to do.
Absolutely.
And just to go one step further, these Miranda rights, these rules were created to specifically prevent the kind of coercion that happened in that case.
They wanted to make sure that all statements were taken from people who were in police custody were voluntary, knowing, and intelligent, and without coercion, voluntary. And those warnings are rules that the police are supposed to abide by and play fairly by. But over the years, slowly but surely, those rights have been eroding slowly but surely. And this is an example of that. Obviously, he was silent. there's some discussion about what actually he did and say. What he actually said. He was there for 3 hours. They were asking him questions about.
So this. Let's just cut to the chase then. So it went all the way to the Supreme Court, and then the Supreme Court said, you know what? If he answered that, then he was in essence forfeiting the original Miranda rights.
First, they said that he did not invoke his right because he didn't say anything at all, and then
he never actually said, "I'm going to remain silent."
Right. So he never invoked his rights, and the court said that if you even interpret that his silence were invoking his rights, he waived them when he actually answered the question.
Let me just bring this in, and before there's so much here, and I'm not an attorney or anything like that, but just kind of thinking logically.
Right.
Is that admission, regardless of how it was gotten, in this case they didn't torture him, but they used a significant amount of coercion, wouldn't any of us say, you know what, he did make that statement, he did say, yes, I in essence admitted that I killed this person, wouldn't all of us who want to see justice served say, you know what, he belongs in jail? I'm sorry that it came out this way, but you know what? Good, he killed somebody, he should go to jail.
Well, we do want to see justice served, but we want to see justice served in a fair way, and that's why we have the first 10 amendments of the Constitution, the Bill of Rights. And so if we're living in a democracy and we feel that even criminals deserve a fair trial, then we should be able to give them a fair trial in this country, and that's what this is about.
So back to you, Mr. Roundtree, then. So why did the court decide that now you have to actually invoke, you have to say, I'm not going to say
Because
anything?
there's a string of court rulings that say that your invocation, your right to remain silent must be unambiguous and unequivocal, meaning it has to be clear that you're asking either for a lawyer or that you want, well, in the past asked for a lawyer, and they want that ruling to apply to your right to remain silent. It has to be unequivocal and unambiguous.
We were talking earlier, and Justice Sotomayor, of course, very familiar to us in the Bronx, wrote the lead dissent, and she had a very ironic point to make out of it. I'll let you state what it is, and then we can pursue it.
Basically, she says you have the right to remain silent, but then it's counterintuitive that you have to invoke your right to remain silent by saying that I have to remain silent. So it's counterintuitive.
It's like, I have the right to remain silent, and so to prove you I have the right, I have to say
that I have
I'm
the right.
going to remain silent.
And so I think that what the court was trying to do, just like Mr. Roundtree said, was that they're trying to elevate the standards for speaking the right to remain silent, the same that they have the right to invoke an attorney as well. So they want both standards to be the same at this point in time.
And I'll ask each of you this question. We can start with you. Does this put people who are not really knowledgeable of this ruling, and partly that's why I would even address it this evening, does it put them at a disadvantage? Because gee, I have the right to remain silent, so I'm going to sit here. And if we don't adjust what they're told, they could just sit here and say, well, I'm going to remain silent without saying anything. And all of a sudden, they'll have not invoked the rights that supposedly they've been given.
Absolutely. And I think also what it's doing is it's lessening the burden of the prosecution into what they have to do as well, because they had to prove by a preponderance of the evidence that, the clients waived their right to speak. So
your thought on the same question?
It's confusing because once you invoke your right to either remain silent or right to a lawyer, police are supposed to cease all questioning.
Right.
So now it's confusing. If you stay silent and don't say anything, the police continue to question you. So the onus is really placed on the suspect to be proactive, to say, I don't want you to question me, I want at all, and actually force the police to stop to question you.
As opposed to the people in the legal profession would be the police and other people who should know how to at least establish the quote-unquote system of justice along the way.
Which the warnings were designed in the first place for.
It's a fascinating thing. One of the things in my research for the show that it revealed is that Hollywood has misled the public, I think. Is that, supposedly, they didn't read me my rights, I'm going free. And that's really not the case, right? Your confession is thrown out, but you could still be, convicted. And then the other thing is, when do Miranda rights apply? That you need to be in custody. You can be questioned, but you have no rights.
It has to be a custodial interrogation.
Right. So somebody has to.
Right. So your freedom has to be restricted in some way, and then you have to be questioned by someone in law enforcement.
In an earlier ruling, and this was another one that flew under the radar, the court decided that if you waived your rights, but 2 weeks later they want to question you again, then the original waiver does not apply. Is this a legal case of gotcha?
It seems that way to me.
In other words,
seems that way to me.
basically you waive your rights, you
But
go
then
through that, and then 2 weeks later they bring you
come
in
back.
for more questioning.
Absolutely.
You basically have to now do it
Sort
again.
of exactly.
Otherwise they don't
reestablish.
apply.
Exactly.
So it is illegal.
I think so.
Did the Supreme Court muddy the waters and muddle the concept here? Because now a suspect is not really going to, what am I supposed to say or not supposed to say?
I think what they did was watered down the Miranda case, and I think they've been doing this through time, and so it's going to be, I mean, they didn't overturn it completely, but I think this was a big dent in the Miranda case, and so it's going to be really interesting to see how the states apply their language. Is the person going to have to say, what's going to be the standard now? Do you have to say, I wish to remain silent, or are you going to have to write something down? I mean, what's the standard each state is going to use? So that's going to be interesting to know.
I'd be curious if there is anybody watching who was in a situation that might have involved Miranda rights and had them read to them, or they were confused about it, or something might have happened. Then certainly feel free to to call in 718-960-7241. Is the Miranda whole concept moot anyway? Because after being read their rights, many suspects confess anyway. I want to talk about terrorism and how this applies to the Times Square suspect. But doesn't that happen anyway, that they read them their rights and, all right, I have the right to remain silent, but through all the questioning, coercion, they confess anyway?
Absolutely, it happens. But, the fundamental right is there. And if we're going to have fairness in the prosecution and fairness with the police interacting with suspects and people who are accused of crimes, they need to be given fair warning of their rights. And if they choose to waive them, so long as that waiver is voluntary and knowing and intelligent, it's fine.
Who really
and understood, yeah.
You agree with that?
Yes.
Who really is, and I'm serious, people who commit crimes generally might not be as well educated as others. I mean, we could do studies of who the people are that commit crimes. I don't think I'm stepping out of turn by saying that. They have to be really well versed in legal matters to handle this and handle this properly.
Well, I'm not so sure about legal matters, but certainly the police have a multitude of ways to get people to talk, and it's all permissible. You can lie to a suspect to get them to talk. You can say that you have evidence that you don't have, or someone accuse you of doing something that didn't accuse you of doing something. You're on videotape, all with the idea to get you to talk. So,
then we go back to the case, the pivotal case here. Do you pray to God to forgive you for shooting that boy
Right,
down?
absolutely.
And that was really a case of gotcha. Absolutely. The whole idea of invoking the Fifth Amendment or saying, well, I'm going to be silent, doesn't that start to suggest to a jury, as much as a judge will instruct a jury on ruling on a case based on its merits, when somebody invokes their Fifth Amendment rights, or if they say, I'm going to remain silent, doesn't that sort of imply to a jury that, gee whiz, you really got something to hide?
It shouldn't. I don't know if it does. But it really shouldn't,
tough,
because
I know, I'm sorry, but
well,
had to
I
ask
mean,
that.
that's why we have our rights, especially our Fifth Amendment rights. It really shouldn't, whether it does or not. It's going to depend on the jury. But
no, it shouldn't, and I guess it depends on how it plays out in front of a jury. Ordinarily, a jury wouldn't hear that the person invoked his right to remain silent. Because that's presidential.
That's right.
But certainly, I've had cases where I claim that the confession was a false confession, it was coerced in some manner, and the whole idea is trying to impress upon the jury that people are capable of saying they did things they didn't do.
Could you give us an example of a case where Miranda rights, one way or another, were administered improperly or administered properly and then not handled properly, or does it come up?
It comes up many times. Police officers, particularly new officers, get someone in trouble if they don't read those warnings exactly the way you read them earlier. If they miss a line or skip a paragraph, that's an improper warning. And if you can prove in court that the complete rights were not read the way they're worded, then that's something that the lawyer can argue.
Although, again, going back to what I was talking about with Hollywood, that doesn't mean your client is going to be getting off. That just means that the confession
may not be admissible in court.
You know, my producer Jane was talking to me about the Central Park jogger case, where we had young men who were now we look back and say they were coerced, et cetera, et cetera. Would this have come in, this new ruling, I'm kind of thinking ahead, would it have come into play in that case? Not necessarily.
Well, the big issue there is that they were all juveniles, and the parents wanted to be there. And the police, as I recall,
That's right.
the police refused to let the parents be a part of the interrogation.
Do you have the sense that, again, going back to this idea of what Hollywood illustrates, are we letting people go because their rights weren't, guilty people go because their rights weren't administered to them properly?
In terms of what society thinks, what
Yes.
really happens?
You tell me.
Well, in terms
Let's
of
do with part A and then part B.
in terms of what society thinks, probably. In terms of what actually happens, probably not.
Do you think this motivated the court, that they are believing in part?
No, I don't think that's what it is. I think the court, it's been long-standing that, you know, Miranda was going to be watered down one way or another. So I don't really think it's public pressure that made the court decide this way.
In this particular
No, I
case.
don't think so at all.
One thing that the Obama administration has been rather strong on, and some believe surprisingly strong on, is what to do with terrorists and how much of your rights you need to have read to you. As I understand it, terrorists, people suspected of terror crimes against the country, the whole Miranda concept doesn't exist. Am I interpreting that correct?
Are they citizens or not?
Go ahead, break it down for us then.
Well, do you want to help?
It would depend if they're considered enemy combatants
Right,
or
that's as
terrorists,
well, too.
then
Right.
it does not apply. But the recent case of the Times Square,
Square.
he's a citizen,
Right.
and what I understand, some politicians didn't want the rights to apply to him as a citizen. I think that's going way far.
And then there was another part of that case, which I think is all. We'll get back to that gentleman being suspected in that case, but supposedly there was a bystander who also was taken in, and he was not read his rights, they said, because you are a suspect in a terror case. And even though he ultimately was questioned and let go, he, because of the nature of the case, didn't have the rights.
But was that a crime scene? Like he was at the crime scene?
He
so
was
a
at the crime
bystander.
scene
Okay,
and
so
seen,
that,
I
so
think
then
he was
sometimes
changing
that
his
happens
clothes
as
or
well,
something
right?
like that.
Right.
Yeah, and there may be exceptions to the Miranda rule under exigent circumstances if it's an emergency.
Exactly.
In that sense, where the officers do not have to read the warnings if they believe it's in an emergency. Like if they're trying, what are you doing? Are you?
So let's talk about this Times Square, this alleged, certainly, I mean, we'll let the legal system play itself out before we convict them on this show, I'll tell you that much. But this Times Square suspect continued to talk. He just went in there, and whether they read him his rights or not, but supposedly he's given up all kinds of information. How do you see that playing out in this scenario? He can do whatever he wants, I guess, right?
Well, at this point, I mean, he pretty much, confessed. He continued to get information, and not only that, the police have evidence that's corroborating some of his testimony. Well, not testimony, but some of what he said as well. So, I mean, I think that.
I think many suspects realize, and this is part of the warning, they realize the jig is up, so to speak, and they're confronted with so much evidence against them, they decide it's probably in their best interest to cooperate.
Give me advice now for people who may be suspects in a case. I'm talking Bronx people who might be suspects in a case, either correctly or incorrectly, how it plays out, and then under this new ruling, what should they be thinking about? And what are their rights, and what do they need to know as they go through this process?
Well, first and foremost, I think all of us as citizens should know that we have our, rights according to the Fifth Amendment, which is our right against self-incrimination. So first of all, I think the first piece of advice would be don't say anything yet. Once you've read your rights, if the police do tell you that, in order to invoke your right, you have to say, in New York, according to this new Supreme Court ruling, that you want to invoke your silence, then say, okay, I wish to remain silent. And at that point, request assistance of counsel.
So
always.
you specifically have to say, now you have to
Yes.
say, I wish to remain silent, whereas
Yes.
before
You
could
did not have
And
to.
when does that reading of the rights happen?
When
On the way into the police car, or in the station, or when
whenever
you're being
there
questioned?
is whenever there is custodial interrogation, so your rights are or your freedoms are being restricted, and then you're being interrogated by a law enforcement official.
Mr. Roundtree, this comes right to where you earn your keep every day. In terms of requesting the lawyer, and at what point in this process are you able to do that? And are there issues and are there problems with how this is being administered? In other words, you have the right to request a lawyer, and yet all of a sudden, a day and a half later, somebody's in jail and they haven't had. Give me that whole kind of.
Well, certainly, if you cannot afford an attorney and you invoke your right to either remain silent or have an attorney, once you're arrested and booked and taken to the precinct and then central booking, you will have a lawyer assigned to you. It'll primarily be a legal aid attorney because we're the primary provider of indigent defense services in New York City, and you have a lawyer there at an arraignment. Now, unfortunately, the lawyer doesn't become a part of the case until that arraignment. Right. So if you request a lawyer, a police officer is not going to stop what he or she is doing and go out and find
you a lawyer so you can,
and bring you into the precinct.
Are you backed up? We're going out of the realm here a little bit, but I'm curious.
We're busy
is it
enough.
difficult now for defendants and for suspects?
Crime is down, arrests are up. Go figure.
So you folks are pretty darn busy right now.
Yes.
Where do you think, where are we headed with this? Do you think the court has now, the way the Times described it, which I thought was fascinating, it said that really all the court did was muddle the question and never really solve the question. Is the court too busy with other things and now they've laid this out? Or do you think this is ultimately going to be something that's going to move us to another series of rulings?
I don't see it muddling it. I think for people who do this daily, they know what the court did. For example, the court did a similar thing with requesting a right for an attorney. That has to be unequivocal and unambiguous. There have been cases where a suspect said, well, do you think I should get a lawyer? And the courts have ruled that was ambiguous. So you didn't invoke your right for a lawyer because you said, well, do you think I need a lawyer? And then the officer said, I don't know. So this follows in the same footpath. They want it clear. The court wants it clear that if you want to invoke your right to remain silent, it has to be unambiguous.
Mm-hmm. I thought it was interesting. I don't even remember at this point. We've been talking about this already for the last 45 minutes, even before the show. That you had said that you don't see it as a political decision. That this was really something based on this case. It wasn't like this big concept that now we've got to do something with Miranda rights because it has somehow affected the legal process.
Right. I don't think that at all. No, I don't.
Do you think there could be a negative backlash, that all of a sudden people will say, you know what, maybe like this gentleman in Michigan, I've been coerced, and all of a sudden then the court will then reevaluate its last decision and backtrack and go in the other direction?
There might be. I mean, I know that after Miranda, there was a huge backlash back in the 60s, and it took the states a while and the police departments a while to really come to appreciate what Miranda really meant. So, I mean, there could be potentially.
It could be, and even discussions like this.
Absolutely. Absolutely. Yes. Absolutely.
So where do you think we're headed at this point? Or what would you like to see? Is there something else needed here?
Personally speaking, I would have liked to have seen Miranda stay the way it was.
Right.
I think it's fine for someone in custody to explicitly request for an attorney, but in order to explicitly say I want to remain silent, I think the court just went overboard, and I don't agree with the decision at all.
You don't agree with it? You certainly agree with Justice Sotomayor.
I do. I really do. Yeah.
Right. And what do you think?
I understand it. I don't necessarily agree with it. I certainly think Justice Sotomayor was correct in saying it's counterintuitive, but the court was clear. It was all fact specific. It had a different set of facts been there, it may have gone another way.
So again, it wasn't, whereas...
It's not a clear line.
Various civil rights people and civil liberties people would say, oh my God, we don't want this. On the other hand, they didn't really make an ideological statement in this case.
I don't think they did.
Very, very interesting. Well, I want to thank you both
Thank you.
for joining us this evening, Golan Harrison and also Timothy Roundtree. And good luck over there at Monroe College. We appreciate you working with young people, and sometimes not always so young people in the Bronx, and
That's right.
teaching some of the things that we've talked about here. We do have, I guess we're going to put out some of the information about the college and also about the Legal Aid Society. We have there, it is legal-aidsociety.org. Folks, last week we had Council Member Oliver Capel, and we had invited people to offer comments. We did receive some comments from the Fort Independence Park Neighborhood Association. So they had offered this after seeing the show with Councilman Capel. They said the Fort Independence Park Neighborhood Association is not opposed to supportive housing. Small-scale supportive housing facilities do not undermine communities, and they say large facilities do. The city administration needs to choose its legacy, provide compassionate housing for the homeless, or import chronic social problems into the outer boroughs, especially the Bronx, with no thought of the long-term impact, or enrich developers or protect and balance low-density family neighborhoods and their economic tax base. And they concluded FIPNA is proposing that Community Board 8 adopt a moratorium on any and all increases in existing social service programming and new sightings. And they added it's time for Councilman Capel to do his job, which is to represent us. They had a rather lengthy email that they sent to us, and that email is available in its entirety if you go to BronxNewsNetwork.org. Okay, folks, if you have further comments or questions on anything you heard on tonight's show or anything going on in the Bronx, then email them to us at BronxTalk@hotmail.com, and we'll read those on the air during a future program. Archives of Bronx Talk are available at blip.tv. Just search for Bronx Talk, and you can see any of the recent shows. Next week, a show about energy alternatives to the black oil that is flowing freely in the Gulf of Mexico. Is it right for your car? Should be a fascinating show, as always. Bronx Talk, Monday nights at 9, here on BronxNet Cablevision Channel 67 and Verizon Fios Channel 33. Thanks to producer Jane Folloro for helping to make it all happen. And to you, good night.
Now, Krista, make sure you stay with her the whole time. She's new to the country. This is her first day. This is a brand new country. It's a whole different culture.
Gonna be okay.
But now make sure you stay with her the whole time. I'll be here right after school to pick you up.
Okay, Mom.
Okay, have fun. Bye-bye.
Bye. Ignore my mom. She's so annoying. She's totally freaking out about this whole thing. She freaks out about everything. She always does that. Ignore my mom. So, you ready for your first day in the Wicked Castle of Doom? I mean, like, seriously, it's so boring. I don't know how they could put us through this, like, every single day. How many schools do you have in your village?